My name is Laura Wilson, Firm Administrator at Wilson Law Group. This is the fourth chapter in Trustee Orientation 101, the trust process entitled The Three-Step Strategy. The presenter of this collection is Attorney Daniel Pertel, Principal at Wilson Law Group. Attorney Pertel is an estate planning law specialist and accredited estate planner, certified by the National Association of Estate Planners and Counsels, and accredited by the American Bar Association. In this chapter, he covers the Wilson Law Group three-step strategy for building a living trust. This section culminates in a visual study of a sample living trust. Remember to take note of any question you have along the way. Let's begin.
Here's the estate planning definition. I want to control property while I'm alive and well. A trust absolutely does not take someone out of control of their property, and they are still in full control. Another part of the definition, planning for incapacity. A trust drafted properly allows for directives to successor trustees as to how the trust makers want their assets managed and coordinated with healthcare agents. Along with that planning, we push our clients to make sure they are having discussions with those who are next in line. A document is only as good as the people that are going to implement it. We want to make sure that disability is not only an appointment, but a discussion. Successors need to understand how to implement directives. The final part of the definition is giving what I have to whom, how, and when I want. Trust-based estate plans are very flexible. We can leave things outright to a child, or we can leave things in trust to a child, which we highly recommend. We can plan for grandchildren, set up special educational trusts, and we can make sure that charities are taken care of. We can also shift the plan over time. It can be changed and amended. We do that by going through a maintenance program that we have established called Our Way, which you can learn more about in the Our Way introduction video within this library. By doing all of the above, we are able to minimize probate and, to the best of our ability, disclose what things are going to cost when we get to the death of the first and second spouse. Instead of being reactive, we are being proactive. It is important that you work with the right attorney. Now, for those of you that are listening and have worked with us, we certainly believe that we were the right attorneys for you and your situation. For those of you that have been listening as successor trustees, you only need to understand what we do and why we do it. This is what we do, a three-step strategy. You need to have counseling. All three partners at Wilson Law Group are board-certified specialists in the area of estate planning and business succession planning. So counseling needs to involve us listening, not just telling you what to do, combining various strategies to provide protection, whether it's from long-term care costs, whether it's shielding the business from creditors, or coordinating planning with the financial advisor. Ultimately, that lends itself to a customized family plan that isn't just about mom and dad, it's also about the kids and then the various differences that happen from family to family. And you need to have someone that is going to help keep the trust funded, which means that we will work with the clients at the very start to ensure that all the assets are either in the trust or directed to the trust by beneficiary designation, and then on an ongoing basis, we will review the funding to make sure that if the clients have changed something, have removed something, or purchased a new asset, that the funding is still coordinated with the overall trust plan. Step 2 is maintaining long-term relationships. This is what our Way maintenance program is all about. This gives us the ability to have a group of clients that we see on a regular basis where we are doing updates on purpose. We are not just doing them because we are reacting to Congress or we are reacting to something we find we can do differently. The families that are in our Way program are going to get updates at least every other year that allow us to roll with the punches, so to speak, on changes in the law, changes in family, changes in techniques, and provide education like this program to successor trustees who are going to need to be empowered and need to understand what their role is. Finally, step 3 is settlement at a known cost. We do the best we can to establish a plan that is going to minimize cost for a family when the plan is in its most important stage, which is during incapacity or death of one or both of the trust makers. This is getting ahead of things, doing programs like this, maintaining the plan, and having a trust administration team with our law firm, which is very specialized. What you're seeing now is what we call a Visio or trust summary diagram that we give to all of our clients. This is a visual representation that lays out the entire trust-based plan from top to bottom and allows people who learn visually to have it in front of them as an excellent tool. As you look at this diagram, you will see three basic levels. The top being where there is a green box and two orange boxes, the middle level where there are two yellow boxes and one green box, and the very bottom where we actually have 5 separate blue boxes and kind of a pink colored box in the middle. So in this scenario, we're looking at a joint married trust plan. If you are an individual, as you look at your diagram, at your Visio, you will actually only have that top level and the very bottom level. What needs to be understood as a successor trustee is that you may be acting at any one of those 3 levels. As we start looking at this diagram, though, please look at the very top left, where we have notated who the disability and death trustees are for the trust makers. What needs to be understood about disability is disability could be in effect at the very top level of the diagram when both trust makers are alive, or it could be at that middle level when we only have one trust maker still alive but that person is incapacitated. So again, looking at the top, there could be a chance that you as a successor would have to step in upon the incapacity of both trust makers. And what we're showing with the green box is the actual revocable trust, and the orange boxes indicate each of John and Mary Sample's life insurance, annuities, IRAs, and retirement plans that are individual to both of them, but that pass into the trust plan upon their deaths by beneficiary designation. We have options that are created in a customized way for each family. One common option would be the creation of a family trust. So the family trust is that green box at the second level, and what that allows for is estate tax planning upon the death of the first spouse. And that means that when the first spouse passes, that spouse's assets, if it's husband in this case, dies first, his half of the joint assets in the middle, along with all of the value of his assets in the orange box, would be available to go into the family trust, and the amount that could go into that trust cannot exceed the estate tax exemption upon husband's death. Any excess above that amount would funnel into what we call the marital trust. So the way that this diagram lays out, we are actually using the applicable exclusion with the balance flowing into the marital trust. The idea with the marital trust in this scenario is to have assets that would have been taxed in the husband's estate not be taxed until the second spouse passes, and we're deferring tax on the marital trust until that time. So then what actually passes to the survivor's trust? Well, the assets of the surviving spouse, which are 1/2 of the assets in the green box, shift down into the survivor's trust, and that trust is still very similar to the original revocable trust. So as you look at that middle level, when might you be stepping in to manage the family trust, marital trust, or survivor's trust? It would likely be because the surviving parent is now incapacitated. So at that middle level, you may have to step in as a trustee to make sure that the assets are managed for the benefit of surviving spouse. As you will see, all of the assets in that middle level are there for the benefit of the survivor. After the death of the surviving spouse, all of the assets are collected, whether they are in the family, marital, or survivor's trusts. They are collected by the death trustees, which in this case would be Allie, followed by Richard, followed by the trust company. And this is similar to what happens with the will as we enter the probate process, but we're not going through probate. We're not going through court. This is a private process that is dictated by the trustees, who are often the children, and the beneficiaries, who are also often the children. And as you look at these distributions, they are equal distributions to each of the children, 1/5 to each of them, and we have each of the children listed there. And each of those distributions, those blue boxes, are each a separate, what we call a general needs trust. And those trusts are provided in the parent's estate plan to provide for protections for the children as the children inherit it at that bottom level. So if we go through each of the children's scenarios, they each have a different way that the assets are going to be distributed to them. If we start with Richard, Richard simply has an outright distribution. That is a traditional way that estate planning is done, where we have adult children. Richard might be very level-headed, no concerns about management, and John and Mary as parents said, we are just going to distribute his money to him outright, and it becomes Richard's, and he has full control of all of those assets. Now, what are the downsides of an outright distribution? The downside is that once Richard receives those proceeds, receives those equivalent assets, if he is involved in a lawsuit, if he is involved in a divorce proceeding, then those assets can be touched by those creditors or that soon-to-be ex-spouse. So as we get to these other trusts, you'll see that there's additional protections we can add in. Erica has assets held in trust, and as you see that she has access for what is called HEMS. We call it HEMS. It stands for Health, Education, Maintenance, and Support. What that allows for is asset protection. So if Erica is ever sued as to the assets that are in the trust, those assets cannot be touched. If Erica ever has a divorce, the assets in her trust are not exposed to that divorce proceeding. But as you look just below Erica's trust description, she also has a staggered distribution. What that means is that she receives 1/3 of the principal of the trust at age 25, 1/3 5 years later, and then 10 years later, after the distribution from her parents, all of the money comes out of her trust and becomes Erica's. So while there is protection while the assets are in trust, the assets as they come out lose their protection. So we do see the staggered distribution as a more traditional way of distributing assets to a younger beneficiary. But the problem there is that as the assets come out, they lose some of that great protection that was provided. Susie has a lifetime trust, and so that means that her inheritance is held in trust for the rest of her life. She has income and principal for health, education, maintenance, and support. So that means for the rest of her life, that is the standard for distribution, which is quite liberal. Health and education is self-evident. Maintenance and support allows for very general, liberal distribution, but again, that provides asset protection. There was specific language as you look at the diagram here for distribution of assets to purchase a house or invest in a business. And then finally, much like Erica's trust, Erica and Susie's trusts, both upon their death, the assets are directed to descendants. Joe, from the way the plan is set up, is very likely someone who has special needs. Maybe he has Down syndrome, maybe he has autism, he could have an injury. And that means that Joe is very likely on government benefits. If Joe were to receive inheritance from his parents without any protections, he would either lose his inheritance in favor of the benefits, or the benefits would be gone in favor of the inheritance. So neither one of those is a good outcome. So the way that John and Mary set this up for their son Joe is that his inheritance is held in what is called a special needs trust. It's a lifetime trust. The distributions have to be made very carefully so that distributions don't disqualify him from receiving state or federal benefits. The trustee of Joe's trust is not Joe. If Joe is the trustee, there's too much control. Therefore, we have defaulted back to Allie and the trust company because of the importance of distributions and how those are made. Usually what happens with a special needs trust is that upon Joe's passing, what is remaining will be distributed back among the other siblings. That wasn't indicated here, but that's a very likely scenario. Finally, Allie has a trust which is a lifetime trust, but the difference between Allie's trust and Susie's trust is that Susie, as you will recall, has a HEMS standard for distribution. That gave her asset protection. As you look at Allie's, she has essentially full access. There's no standard of distribution, no ascertainable standard. And that means that Allie, while she has protection from a divorce, as the assets stay in trust for the rest of her life, unfortunately she does not have any inherent asset protection from a lawsuit or a creditor. And the way that Allie's plan is set up in terms of her trust share, upon her death, she says where the remaining money in her trust go as part of her estate plan. So whereas Susie and Erica have no choice as to their assets going to their kids, Allie is given a lot more control, but at the same time she is given less protection. So as we look at the big picture here, we're doing planning from top to bottom with the revocable trust. And the revocable trust, while John and Mary are still alive, lays out the blueprint for the middle level and the bottom level. And essentially this is a very nice way to review the plan, to get to know more about it. And for those of you that are successor trustees, this would be the one place that I would start out with as you start to look at the actual documents. And this would help you learn more about how things flow from one stage to the other.
This ends the fourth chapter in Trustee Orientation 101, the trust process. If you have any questions about the information covered in this chapter, please contact the trust maker, your attorney, or call or email our office. Attorney Pertel will continue this discussion of the trust process in the fifth chapter entitled Estate Planning Documents. Thank you for listening.